Good morning, colleagues. Let me welcome you all at this roundtable discussion. It's really good that following this match between Russia and Korea that we saw yesterday, it was 1-1 for those who had not watched. Let's begin. Let me introduce our speakers and panelists here. Artur Parfenchikov, Deputy Director of the Federal Bailiff System and the Chief Bailiff of the Russian Federation, Ms. Bondarenko, Anastasia Bondarenko, Director of the Ministry of Energy Department, Ms. Izotova, Head of Legal Department, Federal Tariff Service, Denis Kazantsov, Deputy Director General for Legal Corporate Support, Mosenergosbit, Mr. Leonid Akimov, Legal Director for Rosseti, Tanguy Ervan, Finance Business Partner, B2B Customers for Électricité de France, and Arnoud Willems, Partner for Sidley Austin LLP. We are still waiting for him, getting through the security system, and hopefully in a short while he'll join us. Inter RAO is holding this roundtable discussion for the third time at the Legal Forum in St. Petersburg, and our key focus this morning is on payment discipline in the power sector, non-payments overall in the energy sectors, and as we go on, we will discuss the key problems that promote non-payments, the main reasons for non-payments, with focusing more on the legal framework and legal regulation, and the ways of addressing the problem through legal and regulatory means. Well, the most recent figures as we got from the Market Council and the Ministry of Energy of the Russian Federation and the Russian government are not positive as regards the growth of the payables, which have grown as of January 1st for gas, hot water and steam was more than 1.4 billion rubles, and the arrears excess 359 million. About 67% of those arrears are the power sector arrears, and that is 57% of the total arrears that I mentioned before. Therefore, as compared with January 1st, 2011, the growth was 61% of the arrears. In the generation, it grew 1.4 times, and the arrears on the same grew twofold. On transmission, it grew by 3%, and the arrears grew by 36%. Therefore, the non-payments problem, as we see, is becoming persistent, and further no action policy could only lead to the situation that the power sector remains unappealing in terms of investment, which could cause lack of investment and lack of modernization of the fixed assets, and therefore improving the payment discipline should bring about proper functioning of wholesale and retail markets for electricity, helping to attract long-term investment. Non-payments issues are under control by the Russian president and the Russian government currently, and a lot of attention is being paid to it by the line ministries and agencies and other ministries and agencies. The Ministry of Energy recently held a conference on improving the payment discipline, as well as the Federal Bailiff Services also held more than once teleconferences and same The problem has been discussed at various committees in the State Duma. Moreover, companies themselves try to rescue themselves by themselves, and the companies have started to be quite active in legal drafting. Inter RAO and Mitchell and many other corporations are becoming actively promoting their legal initiatives across the levels of authority, which is quite difficult to do. I know it from my own experience. Still, if you don't do anything, nothing will come out of it. Something has to be done quite fast and efficiently. Let me now emphasize two bills currently being considered. One is with the State Duma about amending individual acts of the Russian Federation in order to improve the payment discipline of the consumers of energy resources, and a federal law draft about amending the housing code of the Russian Federation, about the way of providing the housing and communal services. These are the two key, not all, but key linchpins regarding the payment discipline around which discussion has been on. If you look at the non-payments problem in a more in-depth way, we'll see once again that the power sector is a deeply integrated sector, so that non-payments in the power sector relate not only to the sectoral legislation, but have to do with a whole system of other systems of law and other sectors. If you look at sectoral legislation, we would refer to model solutions to the wholesale and retail electricity markets, which could, from the very beginning, imply a system of financial guarantees, a system of providing access to the wholesale markets. Then we could have avoided many problems, such as accumulation of the debts and arrears on the part of managing companies and communal sector enterprises. Elsewhere, the matters of quickly and efficiently making judicial decisions regarding whatever size of debtors, because currently, as you're well aware, it is not possible to exact debts just because the procedural legislation prevents from achieving fast and efficacious enforcement. In enforcement proceedings, there are systemic factors such as lack of staff, and geography in Russia is very different from that in the Netherlands, which has to be taken into account on top of everything else. Our system of enforcement measures is not fully operational vis-à-vis major debtors in the energy sector, which is another problem that has to be addressed. The administrative criminal laws, as they are now, prevent from efficiently suing non-payers for energy, electricity included. This way, these are multiple problems involving not only the Ministry of Energy. There is also the budget legislation that has to be taken into account. We discussed it with Ms. Bondarenko just yesterday, which has another type of influence on all these processes, so that the arrears are growing and the possibility for the budgets at different levels to provide guarantees. So there are many issues to address. Why don't we focus now on... We only have 2 hours, and we're not able to provide full analysis of all the proposals in the legal area. Still, why don't we try to focus on some major issues? And the floor is given first to Ms. Anastasia Bondarenko. Anastasia, the floor is yours. Thank you, Alexander. Can I have my presentation uploaded, please? Let me start with thanking the organizers, Alexander, you, for the opportunity of speaking here, and let me welcome the audience in this early hour. The Ministry of Energy, on behalf of the Ministry of Energy, I'd like to say a few words about the current situation, tell you about the legal draft that has passed the first reading in the Duma, and share some news about measures about enforcement of this law vis-à-vis the legal community and the federal executive bodies. So this is just a review I'm going to share. Well, the current situation, Alexander has mentioned the key things. Just for comparison, let me say that the debts in the wholesale market in the Russia Federation, there are two markets, the wholesale market and the retail one. In the wholesale market, the debts as of May 1st was 44.6 billion rubles. And there is a downward trend. As from April 21st, it went down by 8 billion rubles. As of January 1st, as from January 1st, it went down by 3.8, which is a very good dynamics. Interestingly, that is mainly because of the introduction of the system of financial guarantees. And the ministry is working on replicating this positive experience over to retail markets. Now, briefly talking about the retail markets and their situation. As of April 21st, the total debts across the participants of the retail markets slightly exceeded 200 billion rubles, which is a lot. And as opposed to the wholesale market, the debts in the retail market are growing. It has grown by 0.14 billion rubles and 62 billion rubles as from early this year. The debt structure looks like this. Non-industrial users 102 billion, households 38 billion, and households include the North Caucasian Federal District as the bulk. And non-disconnectable users account for a large deal of the debts. Those consumers whom you cannot disconnect because of some social or ecological reasons. The Ministry of Defense entities have taken the lead with the debts at approximately 10 billion rubles. And the entities in the chemical industry, like the one in the city of Volgograd, just one entity has accrued about 7 billion in debts, and the debt structure includes not only on electricity but also it's the debt on transmission services.
Analyzing the reasons for the debt, the experts, first and foremost, as usual, see the absence of sanctions. And this relates to such negative consequences as the growth of debt and taking no measures to charge that debt. There's no system of guarantees of payment. There's limited possibility to impose limitation in energy consumption by certain consumer groups, and the so-called lease arrangements, where the leaser is not responsible for the debt of the person he leases the property to. And our commercial community, which also provides their opinions to our experts, say that the courts quite often reduce the amount of sanctions. To overcome those root causes, it is necessary to introduce strict economic instruments, making it unprofitable to delay payments, to extend the system of payment guarantees, which was proven efficient on the wholesale market, and to struggle with lease. What has been done? We've drafted a law on strengthening payment discipline. The motivation to timely payment provides the following tools, as the increase of the penalty, discounts for early payment for utilities, and enforcement measures. That is additional responsibility for such breach of agreements. It is my deep conviction that increasing the responsibility or liability, be that administrative or criminal, will not solve the problem. I believe that we need to motivate the players in the market to pay for their debts, and I believe this will be the correct mechanism. Increasing sanctions or extending sanctions is not always the approach that is applicable, and that is statistics is also different. It's very difficult to analyze the reasons for inadequate sanctions. Let us talk about the draft law. The draft law has been passed by the State Duma at first reading, and it provides for the following. It provides for establishment of a legal penalty for non-payment for power or power transmission services of public utilities in the amounts of 170th of the rate of the Central Bank of Russia for each day of delay, specification of powers of the government of the Russian Federal to determine non-disconnectable consumers. The government will establish the categories of the users whose disconnection may lead to negative consequences, and the lists of those entities will be at the responsibility of the subjects of the Russian Federation, and also the unauthorized connection of infrastructure will be the reason for a higher fine. However, those measures, in our opinion, are not enough, and because of that, we prepared a list of amendments in a number of federal laws. Among the measures suggested are the following: to extend application of the penalty not only to the cases of non-payments for electricity, but also for other types of utilities such as gas and hot water, to extend the application of the Institute of Financial Guarantees applicable to non-disconnectable consumers to supplies of heat, gas and water, to provide for the subsidiary liability of lessors have leased non-disconnectable facilities in case of non-payment by their lessees, to provide for administrative liability for failure of power consumers to provide financial guarantees for violation of the limitation imposed on power consumption, and to provide for criminal liability for repeated unauthorized connection to power, heat networks, or gas pipelines. As for those amendments, when they were discussed at the Ministry of Energy, there was a wide range of opinions, and some of the opinions were absolutely different. Some of the experts were in favor of stringent and what they call adequate measures suggested in those amendments. However, the legal service paid attention to the legal mismatch of those amendments, and I believe that the federal agencies will not support those amendments. If the draft law provides the government with an ability to establish the criteria for the list of non-disconnectables. For some reason, the amendment provides for this list to be drafted by the suppliers, and passing this right to a level of commercial organization may later lead to a violation of law and a discrepancy in approaches to composing those lists. A lot of experts said that it would be very difficult to impose criminal liability because it is very difficult to justify the public danger of such actions, because in their essence, the non-payment is an administrative matter. We got a lot of comments from executive powers. There was a lot of comments, mainly related to a competing law on amending of the communal code. We got a very good comment from the Ministry of Interior concerning the criminal law, because in their opinion this may lead to a clash between different criminal articles of the criminal code. The Ministry of Finance said that if the owner owns some property, their subsidiary responsibility for their lessee non-payment may result in additional costs to the federal budget, and the Ministry of Finance will be dead against. The Ministry of Economic Development also thinks that criminal liability is something too much, and proposes that these relationships be regulated not by financial sanctions, but rather that they would affect the credit history. Well, we could discuss that, although they did not provide a detailed comment. And also the Minister of Justice provided a lot of comments. Because of that, if we take the legal aspect of this problem, we have a draft law which was passed in the first reading, and I believe that we should further promote this draft law so that it should be passed finally, and then we should see how much it would be applicable for the retail market, and then see what happens without trying to impose the mechanism suggested in that law at this stage, because it is not known how they will be working. And also increase the relationships between the bailiffs service, between the other services, and I believe that this meeting will facilitate that. Thank you. Thank you very much, Anastasia. I believe that we'll have the questions after every panelist has spoken. I would like to say that there was a very interesting report by the Government Analytical Center, and it said that there are 3 groups of consumers who do not pay for power and other resources. The first group is that face temporary difficulties, but will be ready to pay in the future. The second group are those who have a permanent trouble with payments, and there's a third group that does not pay irrespective, or no matter what. As for the third group, which constitutes the majority of the population in the country, it's useless to impose any measures and to enforce the law more stringently. I believe that it's only the irreversible responsibility that will work with this group. And I believe that if you illegally connect, you pay a fine of several dozen thousand rubles, but you save on that in the future. I believe this must entail criminal liability. I know it's a matter for a long discussion, but I believe that we need to take different approaches to non-payers, and also we must take the social danger of their actions into account. But that was a brief comment, and I would like to pass the floor to Denis Kazamtsev, the Deputy Director of Mosenergosbyt, and he will talk about the problems that his company faces when they deal with consumers of power. Good morning, esteemed colleagues, esteemed participants of the forum. Really, we will touch upon a very important problem, the problem of financial discipline in the markets of electric power, and I will speak about the retail market of electric power. We'll be talking about the problems and ways of resolving problems in this difficult situation. I will start my presentation with some statistical data on statistics related to the provision of power to communal users. As the previous speaker already said, the arrears for payment for electric energy in the whole market was something like 189 billion rubles in the first quarter of the year. And as Anastasia mentioned, the arrears are soaring. I got the official information as of the beginning of the year, and Anastasia was talking about the results in April, and there's a market growth of arrears. The slide also shows that a similar problem exists in providing heat. In the first quarter, the arrears were something like 160 billion rubles, and the arrears for gas something like 190 billion rubles. Since the non-payment problem is, especially in the area of providing power and gas, as we remember, has never been estimated or assessed by the professional community as a problem that can be successfully solved. The problem only aggravates, and because of that we need to talk about it in a more detailed manner, maybe providing some non-standard, some original solutions that might even seem arguable. Mosenergosbyt, some information about our company. It's a company that provides power in Moscow and Moscow Oblast. It's a company that guarantees provision of electric power. It's a company that must strike an agreement with any customer, and we cannot refuse from signing a contract. The share of the company in the Russian Federation is 9%. And why I'm talking about that? I'm talking about that because our company can be seen as a small-scale model of any provider of power in the Russian territory. So what is the part of the provider. Maybe we will hear something about the electric grids and generation of power. The guaranteeing provider is a company that guarantees payments and maintains the infrastructure. We collect the payments from the end users, we pass on the money to the grids, and pay for the generation in the wholesale market. We also pay for the dispatching services and so on. From the standpoint of a man in the street, this company is a qualified intermediary between the market of electric power, between the professional community and the end user, who is not well versed in these matters. Our objective is to provide the highest quality to the end users, to provide full information, to provide distant services, to provide an ability for the end user to visit our offices. And this all is in the government resolution 442.
What kind of resume can I make? Everything that the supplier guarantees, he can do by means of his own staff, by means of his own resources and his own costs. So any actions that are related to counteracting certain actions will incur or will lead to additional costs. Anastasia has already said about that, that it's really hard to find any civil or public damage or public harm in illegal connections after the new procedures have been introduced. And this is really difficult not to agree. But how does this connection takes place, and how does it look like of a typical consumer? I will finish off with this case and this scenario, and then I will continue talking about the legal cases. Imagine an engineer, an inspector visits a site. He tries to get in an apartment of the subscriber or of the consumer. Imagine he gets in there, and in parallel to that, we're doing a lot of documentation and a lot of paperwork, because in 20 days period you have to warn the consumer, you have to send him an urgent letter that in case of non-payment in 20 days, he will get, well, a limited consumption regime will be introduced, and after that some additional time may pass before the cutoff can be initiated, and not a single consumer will welcome such an inspector at his house and will definitely sign any acts or any papers. So there's a whole range of different barriers you have to overcome. There's another set of barriers. You have to physically get to the metering station, you have to physically get to the electrical board and cut it off. And as soon as the inspector does that, does the cutoff or does any other things, the consumer gets out of his apartment, connects himself back to the grid, and continues to consume. So the objective is not met in this case, and as it is known, any limitations of deliveries, non-deliveries, is a good measure enough in case of non-payment. And in our case, we must provide for and we must deliver a product that we are not being paid for. And I think for such consumers as we're talking about, we can really start thinking about charging them with ill will or ill wishing and probably theft. So That is the way we can treat them. And I have already moved on to the next slide. Let's have a look at the next slide where I describe the reasons why physical entities people are not paying. Well, first, lack of motivation, because the available measures of property administrative liability are ineffective. I already told you about the administrative liability. We believe that such an institution has to be introduced. As for property liability, these problems are not under my jurisdiction, and I will not talk about that. Anastasia has said that the law tries to deal with that, introducing a fine of 170th share of the rate of the Bank of Russia. And today, any legal entity or any physical entity can get a credit, can get a loan at a rate of 8.25% by not paying. Such a rate is difficult to find now in the open market, and until we raise this rate to a certain level that is not feasible or is not viable for the debtors, we will not be able to resolve this problem. So today this particular issue is being discussed at the State Duma, and I hope that the outcome will be positive. The second problem and the second reason why the private people are not paying is the presence of intermediaries in the shape of managing companies between the consumer and the resource supplying entity. Such managing companies were established in the first place in order to ensure that there's a new model of management, of governance in the housing industry, in the housing sphere. But unfortunately, or maybe fortunately, life is much more diverse than the law. And very often, such managing companies, in worse cases because they're not qualified, and, well, in better cases because they're not qualified, and in worse cases because they would like to violate the law, they just accumulate a lot of debts. They tell that they don't have any means to enforce people to pay. They create new debts, and sometimes they become bankrupt, and after becoming bankrupt they will re-establish themselves, invite the same people all over again. And today there's a new law being reviewed at the State Duma about providing and issuing licenses to such housing management companies. Definitely this law will help us to avoid any indecent, any illegal managing companies from coming over and playing in the market, but we require a whole set of different measures and instruments that will allow us not just to exert some administrative leverage, but also other types of leverages. For example, we must have an opportunity to withdraw from any contract relations, any contract liabilities with non-payers. And we must establish direct contract relations with consumers. Unfortunately, this kind of construct is not yet available in the law, or the one that I have described to you right now. However, sometimes these kind of contracts do appear on a one-off basis between the supplying companies and the consumers, but our regulatory authorities are very careful about this and are very cautious about that, and they ask a lot of questions that are too hard to answer for a supplying entity. There is also a possibility, a reservation provided by law number 442 well, there's a possibility of going out from the contract relations because you are not consuming all the resources provided. And but since the autonomy of our consumers' will is quite limited, our managing companies can really bypass this reservation, and the supplier company may be excluded completely from such a contract. And there are some other problems of legal regulations. I will list them now. There's a complex mechanism of introduction of the energy supply mode restriction. There's a problem of information exchange between the state authorities and resource supplying organizations. MOS Energosbyt has 6,700,000 consumers. We don't know our consumers. We don't know what is their name, who are they. Historically, we just know that the money has been paid, but who owns the apartment? Who pays for that? We don't know the sizes of such apartments in order to calculate the rates and tariffs. We don't have the opportunity to obtain additional information. For example, if there was an old consumer who stopped being our consumer, and we have to cancel some of the benefits that were provided for an elderly citizen, for example. And there's another problem of non-executing court orders or court decision. And I would agree to Oleg that a number of outstanding questions still require additional discussion, and we see there's a clear need of introducing new mechanisms in terms of court order enforcement and execution, and what suggestions are there as far as physical entities are concerned. At this slide you can read the two last lines because they tell about that precisely. As I said, physical entities, private persons, are not paying because they're not disciplined enough sometimes, and you have to really go to the court, and you have to ask the court to issue a court order. It's too difficult to launch an extended and a lengthy court procedure because it's really hard. It will be really hard to argue in this case. And today it's very difficult to get a court order because a court order can only be provided if there is a written kind of an agreement. But only a limited number of consumers would have direct contracts with supplying companies. So that's why MOS Energosbyt decided to initiate introduction of changes into our civil code about these court orders. Moreover, well, as soon as the court order comes into force, this court order must be adequately responded to and must be adequately executed. But I can tell to you that MOS Energosbyt does a lot of work as far as optimizing our work with bailiffs is concerned. During the all-Russian meeting, Oleg has voiced and information has said that there is an electronic data. There's an electronic database, and there's a possibility of e-data exchange. We tried it and tested it ourselves, but we saw that basically this database is used by the debtors themselves, especially those who would like to leave the country for a short while and they want to find out whether they are in some lists or in some database or not. So I would like to say that if such additional cooperation with bailiff service will allows us to introduce a new service of, say, personal cabinets or personal offices in this data space, then I think our work would become much more optimal, and we will be able to avoid this very complex system of communication with different bailiffs, because you really have to stand in long queues in order to get through to bailiffs and to some of the bailiff services. Now let me talk a few words about the legal entities. Actually, we deal with similar kind of problems in this domain as well. Anastasia has said a lot about that. Different state unitary enterprises and federal unitary enterprises are presenting a lot of problems, and there is a problem of non-disconnectable consumers as well. Also, execution is extremely important. Execution of court order. We really must bring back our system of bonuses for bailiffs, or the system of motivation for bailiffs. For example, a 7% rate that you take from the total amount of debt. This system used to exist in the past, but then it was cancelled, and we don't believe that this is good, because when a person is doing some work, he must be stimulated for this work, he must be paid for that. We've sent our request to the Russian grid company, and this request will soon be transferred to responsible state authorities. This is it as far as I think most important things are concerned. This topic is very extensive, but I do hope that during our question and answer session I will be able to add up on that.
Thank you, Denis Vladimirovich. You have explained how you can not pay for electricity and then go abroad by getting into the data bank and tampering somewhere there that only you knows how to do this. Artur Olegovich, why don't we give the floor to Mr. Parfenchikov? It's about people who have debt as part of the enforcement proceeding. It would be quite interesting to hear what you have to say about this and what the Federal Bailiff Service has been doing. Thank you, Alexander Alexandrovich. Thank you, Alexander Alexandrovich, for the invitation and this honor of taking part in this session. This is to say we have very constructive, good working relations indeed. Recently, we met with representatives of major energy companies here at the Federal Bailiff Service. We had a teleconference, all-Russian teleconference. It was a good working dialogue, very open and sincere, and obviously it was helpful. Many of the issues we posed are being worked on now, and of course we are working on a more convenient data bank. We are preparing a workshop in order to better understand how we could move on and proceed. There are interesting legal draft initiatives, and we are working with the Ministry of Justice in a more specific way on making this happen. Hopefully we can achieve some good results there. So the work is underway, really. Of course, I'd like to share some figures. I beg your pardon for having to do this, but indeed, this is the kind of activity we're in. You will see some tables on the screen so that it is easier for you to perceive what are the developments this year. For the 4 months, we're 2 days short to give you the data for the 5 months of this year. So it's only for the 4 months, January through April, but it's quite informative as it is. Over the period, we had over 1 million of proceedings with a total amount of 83 billion rubles. This kind of claims we have received. On physical persons, it's 1 million cases. The amount is not that large, although it is big, 21 billion, 21.7 billion. But it's just a quarter of the total. While legal entities, there are 40,000 claims for the amount of more than 63 billion rubles. And sole entrepreneurs, 6,200, and the total amount is, like you see on the screen, the total indebtedness across the types of consumers and types of energy: electricity 40.6 billion, heat 23.5, and gas 19.3 billion. This is the structure of the indebtedness. The total number of cases relative to the same period last year, 4 months of last 2013, increased by 15%. received for action were we had 388,000 cases for processing, which is again an increase over the same period last year. The number of completed or terminated cases increased relative to last year by 9%, and enforcement up to 20 billion rubles. There's been a 14% increase of the number of completed documents acted upon. There used to be 131,000, now it's 152,000 cases, mainly working with individuals. While what we do in the area of working with large debts and large debtors, mainly legal entities, of course, that has improved several-fold. The total amount is not that impressive. Still, over the 4 months this year, we managed to exact 4.3 billion rubles. It's partial exactment. Some debts are still there, but this is what we managed to exact, as opposed to 1.2 billion rubles. So the improvement has been considerable, although much work has to be done yet. This way, we managed to actually to transfer 14.3 billion rubles, 3 billion increase over the same period last year. Why these successes? First of all, by more intense work of ours, we more actively use whatever sanctions we may impose vis-à-vis the debtors. It's been we've seen a several-fold increase. We had 16,000 limitations on exit abroad, more than last year. 5,500 arrests or seizures of property, again on a greater scale than last year. And we used administrative measures 2 times more often against the debtors. Of course, we used, however complex the processes are against hardcore debtors, we used criminal prosecution. We initiated 54 criminal cases against the managers of corporates for their debts in supply of energy. Criminal cases were under Article 315, but there were also 9 criminal cases that we initiated under Article 177, which is evasion of paying debts. And we had some cases against the debtors who try to conceal their property. These are pinpoint figures, but these are very difficult cases, very difficult articles for shaping the subjective and objective corpus delicti, and I think these are quite serious successes. At least they should be a good prevention, should be perceived as a good prevention for potential debtors, non-payers rather. Of course, there are some problems in the process of exacting. We keep discussing them, including at the conference I mentioned before. There are issues already mentioned by the colleagues before me about how long a court proceeding may take. And most importantly, it's not only the duration of a legal process. The worst thing for us is that during the process, for whatever reason, I'm not pointing out fingers, but injunctions are applied too seldom. When injunction is applied to the debtor's property, the figures go like this. satisfied claims for claims against legal entities. Of course, I'm talking about legal entities primarily in this context. 61.3 billion rubles of the claims that the bailiff service received, but injunctions were applied only to 0.6% of the total cases. That's the reason number one. While all the court proceedings are underway, claims, receiving complaints, it can take a month, 2 months, but there's no property to seize. And we see that some companies specifically established for this, because by the time the court proceeding begins, they have nothing, and you can't take nothing from them. It's too bad we don't have an opportunity to work actively at an early stage. Even before the claim goes to the bailiff service, it's already doomed to exact this debt. Of course, another serious problem is various related persons, affiliated entities, where the money would be transferred to third parties' accounts. We try in such cases to work with our partners, with the recoverers, but it's been quite difficult despite our recent success in Ossetia. Another impact on the enforcement comes from the revoking of the claims. In 4 months' time, we got 13,000 such proposals from the recoverers, from the plaintiffs, but 9.3 billion rubles might have been recovered owing to the measures we had conducted and the dialogue that started between the plaintiff and the debtor, which is quite an acceptable process. But when it comes to suspending or delaying of enforcement, that is a real serious problem, because I gave you the figure of 83 billion, and mainly those 63 of them being against legal entities. In 4 months' time, we got this kind of delays from the courts for 8,000 claims to the amount of more than 11 billion rubles. There's nothing we can lawfully do against that, because the respective decision has been made, so that some active court debate continues after the enforcement proceeding is underway.
Of course, it also relates to the bankruptcy problem, and certainly when we send the documents to the liquidation committee, and in the 4 months of this year we sent 1,200 of such documents to the amount of 3 billion rubles, but problems arise when we work with payments, and because those payments, well, I would like to say that they become the victim of tax office, and the tax office pays attention to these amounts, to this money, and they also recover that money for the purposes of the tax office. Of course, the problem is that quite often our debtors have a whole bunch of debts, and not only debts for electricity or power, and it's a problem of the order of paying debts, and quite often will have 38,000 cases to the amount of 10 billion rubles, which we cannot recover because we are recovering, because the first stage debts are being recovered from those debtors by other entities. So what do we need to do to increase the efficiency of our activity by joint effort? Certainly when we are discussing those problems, and we'll be talking more about it today, a lot of issues lie beyond the enforcement proceeding, because it is really a tangle of problems which have been accumulating for a long time. Can we do something for the debt not to accumulate and the matter not to be sent to court? Speaking about the bailiff service, certainly we will be continuing to use the methods available to us right now, including the criminal liability. I hope that we will be able to work not only with the matters within our competence, and that's Article 307 and 115, Article 115, and certainly we need to work actively with the recoverers, establishing such cases as fraud, and I support all the measures that are being taken. We are drafting model documents, model claims, and we understand that our experts, our lawyers from the companies, they're great expert, and they can help us law enforcers to better see the problem, which is related to the criminal procedural matters. Certainly we hope for electronic execution, and this is a trend that the bailiff service is very much developing. This will allow us to optimize the enforcement and recovery of debts from physical persons, and quite often those physical persons fail to return their debts just because they are inattentive, because they don't care much about their credit history. And we really hope for that electronic execution system, which will facilitate our relationships with the banks, with the pension funds, with the payrolls organizations, and our objective is difficult but achievable. We are planning by the end of the year to arrive at a situation when 40 to 50% of all of the cases that end with execution will relate to electronic enforcement, when the bailiff will not need to leave his or her office. They will be working with the computer, with the software that has been developed for the purpose. In particular, if we're talking about St. Petersburg, St. Petersburg is in the lead of implementing electronic technologies. In June, they provided 48% of all the recoveries by using electronic system. Of course, the average for Russia is 10 to 15%, but St. Petersburg was a pilot project, and I hope that within a few months the rest of Russia will catch up. I mean, the other regions of the Russian Federation. As for the personal room, I believe this is a very much needed institution, and It is mandatory that the debtor can see his credit story, that he may know that he has to pay the debt, because there are examples when people just don't know they need to pay for communal service or for utilities. And we see that in the first quarter of 2014, 13, the physical persons directly used the electronic payment resources located on the website, paid 17 million rubles. That was the initial amount. But in the first 3 months of this year, they paid 95 million. It's not billions yet, but we can see that the amounts are growing geometrically, and I hope that this tendency will continue. So the personal area where the debtor can communicate with the bailiff directly. And 2 years ago we got an amendment in the law on enforcement proceeding, which allows the bailiff to provide the legal documents in an electronic format. Before that we only worked like that with the tax office. Using the availability of that provision in the tax code. And now we are transferring to a wider application of this principle, and I hope that through the portal of state services we'll be fully using it by October. Our purpose is to provide that service to all the debtors. In principle, the system is ready. We're just fixing some bugs right now, and I hope that our recoverers will have that opportunity by the fall this year. And we need to do away with long lines of visitors in the bailiffs' offices and in the legal offices. I hope that this will impact the payment discipline. It seems to me that we've made the first step in forming such a resource that would provide a publicly available credit story. And this will add to the functionality of the Bank of Enforcement Proceeding. Previously, that bank contained open information on the current enforcement proceedings, and if those proceedings were over because of the failure to pay, that information was erased from the data bank. Now we have a resource that allows us within 3 years to keep that information in the data bank. Now we can present our data bank of enforcement proceedings as a 3 years credit history. So if the person is on that bank, they have a negative credit story. If they are not there, they have a good credit history. And I think it's very important to emphasize the second part of that system, so that people try not to get on that list of debtors, so that they can gain some preferences in the banking system or in the insurance system if their credit history is positive. This is the situation as of now. Once again, I would like to say that I hope that our active interaction will continue. Today, within the framework of this legal forum, and in the future we're planning some seminars that we will have every 4 or 5 months to monitor what's changing because of these decisions that we are making. Certainly, by the result of our discussions, we decided to actively use the tools of special enforcement proceedings office at the chief bailiff of Russia's office, and a number of cases have been already passed on to the chief bailiff already, but we also strengthened the importance of our regional offices, and wherever we're talking about enforcement proceedings in the area of energy, or where the defendants are legal entities, such as big companies, all those cases will be under the surveillance of the Special Enforcement Proceedings Office. We were allowed to do that by a new amendment in the law. When the law on enforcement proceedings got a new system that allows to create interregional groups of bailiffs, inter-district, interregional, that will provide for a better execution, enforcement. So even if the company moves, they will still be under the. They will still be followed by the Enforcement Proceedings Office. Thank you. Thank you, Arthur. I believe that it is only now that the big business can afford such conversations with the Federal Bailiff's Service. Of course, it's very important for us, and it's very important for us to communicate to you during the meetings arranged by the Ministry of Energy, but I will dare to ask several questions to you. I have a number of questions, and if possible, I would ask you to briefly answer them. The first one is a conceptual one. What's your assessment of the system of collectors agencies in Russia? How efficient are they, and what is their relationship with the Federal Service of Bailiffs? And my second question is as follows. You mentioned your interaction with a banking system that is being developed. To my opinion, this is a very positive thing, and this results in providing you with data of accounts that belong to physical and legal entities. And the third question is the limitation of limitations imposed on debtors concerning their leaving the country. Thank you, Alexander, for very interesting questions. I will start from the last point. As for limiting their travel capabilities, of course, it's a very efficient measure, not from the standpoint of a direct effect, but I believe this is, in general, a preventive function. As of now, quite a lot of citizens of Russia know about the danger of that measure being imposed of them and behave correspondingly. I certainly support that this measure be applied to the top managers of major companies, not only physical persons. We have a draft law proposed by Bashkiria, which suggests that the top managers who do not comply with the court rulings are fined, and that they are deprived of their salaries. Also, that there might be criminal liability, but the limitation of their travel capabilities, the prevention of them leaving the country, is a very interesting matter. But we must understand that this is not criminal liability, this is not administrative liability, this is an enforcement measure. We can have a whole scientific discussion on that, but in principle this measure is automatically applied unless the person does not pay the debt. And 2 years ago, jointly with a group of experts, we developed amendments to the law on enforcement proceedings, and we managed to justify this action, such an action as a measure of enforcement. As for the banks, the measure of compulsion. As for the banks, I believe that freezing the accounts is the measure that we can apply, and also withdrawing the money from the account. And we are trying to arrange the document turnover. We get the electronic the information in electronic format, we freeze the accounts, and now we need to implement the system of electronic withdrawal of money from the debtor's accounts. I believe that our collaboration with the banking community is very active. We had some problems a few years ago when we had a gap in that process of seeking the accounts, and it took some time for the bailiff to find the account, and when he did that, the money was gone. Now we managed to overcome that gap, bridge that gap. There is no problem like that right now. A number of our foreign colleagues, in particular the Dutch bailiffs, really envied us because they still have that problem, that they have a gap between finding the account and freezing the account. So that's the situation. So I'm optimistic about that interrelation. Certainly we are mostly working with major banks, but we would like to develop this system further. I've recently been in the Far East, and I've seen that some medium-sized banks start to collaborate with us because it's profitable for everyone, because we take away the huge paper burden from those banks.
As for collecting agencies and collectors, I'm positive about them. I understand that we live in different environments. These are two different niches. Collecting is a problem that has to be dealt with in a step-by-step basis. And definitely it will serve to the benefit of all the parties if the parties first agree on a certain consensus. That could be an ideal situation for us, without any court rulings or court decisions or court orders. And second, if there are such court rulings or orders, it would still be nice if nobody is being forced to do something, and we are basically finding a consensus. So executing court orders and searching for different forms of cooperation, such as mediation or buying of debts, these are the two things that need to go hand in hand. Sometimes you can buy debts without even a discount. It depends on how developed your collector's market is. Also, such collectors they would only benefit from having a legal representative that would deal with the consumers, with the debtors, basically. And there are different leverages that we can use. Today, if somebody wants the beneficiary, if they want to get their money back from the debtors, they can refer to a bank, or they can refer to certain departments of a company that is indebted and get certain amounts of money without any additional arrangements, up to 35,000 rubles. It worked for some time, and we were lobbying this kind of issue and this kind of possibility with some scientists, with experts from our Ministry of ministries. And today we can also refer to the help of private detectives, which is another good thing. There are private detectives around in the market, and if there's some information available about property, this information on property, on the fact that somebody owns something, well, it means that we know more about the person than he really wanted to, and this already serves as a ground for mediation. If we just come to him to drink tea and without any ace in our sleeve, then this mediation will not work. So as soon as we sit around the negotiations table, as soon as we show this person, the debtor, all the papers, and as soon as we tell them that tomorrow the bailiffs will come, probably such mediation can be achieved and a consensus could be reached. So this is what we are calling for. Using the private detectives outside this framework of state court orders execution. And I think this is a normal practice. So collectors for us are professionals. I can give you an example. We work a lot with our colleagues from Finland. We have a lot of things in common, including the history of our systems development, systems of enforced execution. Collectors' market in Finland is very well developed. There are even several laws that regulate this activity. And 2/3 of all the debts that our Finnish colleagues are working from are some debts that are the debts that have been already bought over by somebody. And it means that the market is very well developed, and this is the way I would like to talk about this problem. So I'm very positive about the collecting activities, but of course only when it is legal, only when it is transparent, because this is very convenient for all the parties. Thank you very much. Just the day before yesterday, I was told that one of the energy companies in St. Petersburg put on tender a debt of a certain company, either a utility company or a consumer. And they were using law number 223 on governmental purchases, on governmental sourcing, to sell off this debt on the tender. Thank you very much for a very interesting presentation. Let's give now floor to some of the experts who will talk about two more questions, such as tariffs, how the tariff policy of our government influences the problems we're discussing currently, and to an expert who will talk about an issue about debts to grid companies. Let's start from the Federal Tariff Service. Anna Izotova, the floor is yours. She's representing the Federal Tariff Service of the Russian Federation. Thank you very much, Alexander. We constantly hear that tariffs is something to blame. Luckily for us, we haven't heard about this today. Well, the ball is on your side, and the ball is on the Federal Tariff Service side. But everybody says that tariffs are to blame. At present, tariffs have nothing to do with non-payments. And I mean that in setting up tariffs, we cannot account for measures that would stimulate our consumers to pay. And there are no measures that can be implemented to avoid non-payment. So you cannot really resolve this problem through tariffs. Apart from one thing, because the law now prescribes certain compensatory measures to various organizations. Compensations in an amount of losses that they incur because of non-deliveries and non-payment for delivered resources. But unfortunately, maybe fortunately, this measure is not fully compensatory, meaning that you cannot get a 100% compensation. Otherwise, the company will never be motivated to get back the money. And there are several possibilities. An organization may take a loan if they want to cover their debts or if they want to cover their losses, and any percentages or any rates they have to pay for servicing the loan will be included in the tariff, in the cost of energy or of the resource. And these percentages or these rates can be included into the price in a different way depending on what methods are used. There is also another possibility of compensating. You can prepare or you can establish a certain bad debt reserve, or you can write off your bad debts. Again, these opportunities are very limited because in electrical energy it's only 1.5% of the gross revenue requirement, the reserve that you can make, and in heat supplies it's 2%. So basically you have to write off all of your bad debts, and you have to account for this bad debt in your rates and in your prices. But if the organization has both the reserve and has an opportunity to write off, they write off only the amount which is not included into the reserve. There's some limitations, unfortunately, and sometimes these limitations do not provide for full compensation. But are there any particular solutions to this problem? Minstroi proposes the following draft law. It proposes to introduce some changes in the federal laws on electrical power sector and on heat supply. But these laws have not yet been introduced to the State Duma. They're just discussed by some federal regulatory authorities and bodies. These bodies have issued their comments, and the government was reviewing these comments, in particular the deputy chairperson of the government. And one of the measures for improvement is to provide discounts for tariff rates regulated by the state. This is a very good topic for discussion, maybe not at this venue, but at least such things have been voiced. The state regulator may after introducing tariffs, identify the discounts that can be given. Right now, nobody understands the way such discounts can be introduced or the way they will be implemented. It will still be discussed, and probably some decree will be issued in the future. Well, Alexander, this is all I wanted to say in brief. Thank you. It would be really nice to have such discounts that you are talking about, because we're all decent payers, and definitely we would want to pay less for being so good. As for our grid problems, let's listen to what Leonid Akimov has to say. He is a legal director of JSC Rosseti, and then we will gradually move on to foreign cases, because foreign experience is extremely important for us. We might consider it in developing our own legal framework, and it will be very good in discussing the environment overall. So, okay, Leonid, let's talk about the problems that exist in greed companies. Alexander, thank you very much. You really must search for good things in bad things, and non-payment is bad, but this problem unites us all. It was the purpose for us to meet in here and to discuss how various companies strive to resolve this problem. I've never seen this unity, such a unity, and thanks to close cooperation between the Ministry of Energy, between Artur personally, the bailiff servers, and our company, I hope we'll be able to really raise the bar in this discussion, because a lot of particular measures are being taken on board right now, and various measures are implemented well. The thing is that all our elements of the system, all the generators, all the transporting companies, they form a backbone of the economy of Russia, like a blood circulation system of our economy. You probably know that not just in here, but also in the world, there are some specifics that come into play, and you must account for them. But this is not the only thing that really matters. International tendencies and trends have to be taken into account. In 2008, we made a really significant step forward. From bartering procedures, we moved on to a different level. And but on practice, we faced a situation when barter seems to be quite an appropriate way to go forward. Definitely, legislation in the area of energy is quite young. In 2003, the first law in this sphere appeared. All our norms and regulations appeared before the reforms, and in 2008, the whole system of norms and regulations survived or suffered an experiment or a test, a shock, meaning the world economic crisis that definitely hit Russia as well. And notwithstanding that the law on energy and some norms and regulations that we have shown on the slide form a uniform system of energy regulation, there've been some changes, but the only things remaining intact are the principles that were formulated in the law on energy. First, to ensure energy safety of the Russian Federation. Second, technological unity of electrical energy. Third, uninterrupted supply of energy for meeting the consumer needs, the freedom of doing business in the energy sector, and striking balance between the economic interests of the suppliers and the consumers of electrical energy. Establishment of non-discriminatory conditions for entrepreneurship in the electrical energy sphere. This word balance is a key word not just for our seminar in here, but it has been heard a lot of times in the discussions between the governmental bodies and in the players of this market. We really need to strike a balance between the norms of administrative enforcement, the balance of civil code norms, and so on and so forth. Only these things will allow us to create a decent systems. Here we show the debts in the electrical energy sector. Unfortunately, still we can see a negative dynamics, meaning that the debts are going up. If we have a look at how our indebtors look like, what the overall portfolio consists of, to the left and to the right of this diagram, you can see how do we interact with this indebtors, and what debts are being accepted or and not and what debts are not accepted. And we see that very often the consumers are being protective, and this problem has been brought up at the recent meeting with the president. And to our mind, definitely we're trying to support our Ministry of Energy. We are trying to participate in the work of creating new laws and regulations, but still we believe that we must make the existing laws work, the laws of the civil code. And these norms must be easy to execute, or at least feasible to execute. The court rulings must be followed, and all the criminal prosecutions must be brought to their end. And how to make this problem better? Well, imagine there's an interview. A good person is asked, what do you think we need to do in order to make this world better? He says, we need to kill all the bad guys. I'm afraid this is not the path we must follow in the electrical energy sphere, because we're trying to build a legal state first and foremost, and the backbone of a legal state is norms and regulations, norms that motivate people to behave decently and become law-abiding citizens of the country. We, as a ministry, like the ministry, we're very cautious about creating new types of criminal violations. We are all supporting the activities on making the old laws working. And we must propose different tactics of meeting certain tasks and objectives. For example, there's been a whole range of proposals that were introduced by the Ministry of Energy, and in particular, ensuring payment guarantees. And possibly the Market Council is one of the measures that can be very useful in here. And that can improve payments for electrical energy in general and paying for the services as well. Let's have a look at the current regime, how existing electric power payment lag behind the payment for services, and we want these things to be synchronized. And if all the parties in our civil environment if they become decent partners and law-abiding partners, I'm pretty sure all of the parties will be satisfied. Now, all of the proposals have to be finalized, but all of the key things that Anastasia has talked about were and are supported by all the businesses and companies in this industry, and we believe that this draft law and the draft law that is proposed by Minstroi, they must be finalized, taking into account the following things. There should be a balance between the interests. Payment for services, this system must be balanced. Concession agreement law must also be introduced and finalized, because there's a number of clauses that are being violated and very often used for illegal actions. And also you must be very delicate and you must be very cautious in strengthening the norms of administrative liability on illegal connection to the electrical system and electrical grid. Thank you very much. Leonid, thank you so very much. Sorry for not paying enough attention to this topic, or paying only a limited amount of attention. But as far as I'm aware, and what Anastasia has said, payables is almost a no topic for the grids. You are not referring to the Federal Tariff Service anymore, and you are being one of the leaders in this area. But there's a number of proposals that are being introduced by the companies in the electrical energy industry that will help to ensure that the debts are paid for all the energy suppliers and all the grid companies. Well, these proposals must definitely correlate and must definitely be synchronized with what's proposed on the governmental level, because all the money that you're receiving as payments, this is the money that comes from all the consumers. So we definitely must take into consideration also the norms on protecting the consumers. Basically, you have to use the same logic, like percentage payments and so on and so forth.
So now I'm taking the matter that we would like to ask and have responses from our international colleagues. Let me remind you that present here are Revan Targui from EDF, Électricité de France, and Arno Willems. As far as I remember, Sidley Austin LLP, correct? Fine. Arno, this is the third time, I believe, for Arno. He's a highly professional person in energy matters. The only thing I would like to ask you, since we had an interesting previous discussion before and we took a lot of time, we would like to hear your assessment of what you have heard this morning. And of course, we would like you to briefly focus on more specific things discussed earlier, systems to guarantee the payments, connections, if any connections exist in Europe, the way the system exists, how good is the payment discipline. I was told yesterday, for instance, that in England, people did not understand what it is not paying for electricity. Maybe it is different. In France, maybe people in France are smart enough to know how not to pay for electricity. So why don't we give the floor to Mr. Tanguy first? Ervan, you have the floor.
Good morning. Thank you, Alexander, for your invitation. It's a pleasure for me to be here today in St. Petersburg. So I'm going to speak this morning, unsurprisingly, about payment practices on electricity markets. I don't have sufficient science to speak on a legal perspective or as a lawyer. I'm going to speak as a manager in a group supplying electricity on having to organize and deal with payments from customers on a daily basis. Within EDF Group, among other things, I've been responsible for credit control and credit risk for B2B customers in the UK. And I am now in charge of finance for our B2B customers' activity in France. So let me introduce very briefly EDF. You may know EDF, but so I don't know if you have the... Thank you. Yeah, you may know EDF. EDF is a global leader in electricity, covering the full range of electricity system activities. It's a leader in terms of its sales, 75 billion euros a year, which makes roughly, I guess, 4,000 Russian rubles. It's a leader also in terms of generating capacity with 140 gigawatts. It's a leader in terms of number of customers, 39 million customers, mainly in France, but also in the UK, in Italy, in Belgium, and also in Poland and in Brazil. EDF has gained a unique experience of the upstream and downstream electricity chains. The group energy mix includes the full range of generating technologies, but with a major focus, as you can see, on nuclear and hydro. So, we operate mainly on three markets: the wholesale market, where on energy trading activities, where we operate through EDF Trading, which acts as the interface between the group and the markets. So in this market, we have credit issues, but they are limited because of licensing mechanisms for people acting on the wholesale market, and also with methods that are very similar to to the way credit risk are managed in financial markets. So I'm not going to cover particularly this market, except from some tools in common with B2B retail activity. The second one is B2B retail market for business customers, from multinational customers to shops. So the electricity for them is always absolutely vital for their business, making it a political stake in many situations when we have payment issues. And the third one is residential customers, B2C market, retail market. For them, it's even more important. It's not a question of business, but electricity is vital for their own family, and it makes the commercial relationship with each of these customers particularly personal and sometimes difficult when it comes to late payments. So what, on these two retail markets, what are the similarities, what are the main differences? So we, as I said, electricity is always vital for each customers. What is very specific, although you could say that it's the same for restaurants and hotels, for electricity, the energy is consumed before it can be measured and then billed and then paid. So it means that for suppliers, they have to manage a permanent exposure and deal with working capital requirements, very important to be under control. Business customers, very quickly, the contract, because the contractual part of it is very important. It's where everything begins in terms of late payments. So the contracts are generally for fixed term in the European market, from 1 year to several years. The payments terms are sometimes negotiated with the biggest customers, sometimes with complicated mechanisms around factoring, reverse factoring in place on the customer side. Payments are made by bank transfers, and I'm not going to cover the main reasons for non-payment, as you have already covered a lot of that. But it's not always, just to mention, that it's not always for financial difficulties. It can be simply sometimes a lack of organization or dispute of invoices sometimes. For residential customers, the contracts are for undefined or undetermined periods. The billing and the payment terms are never negotiated. They are included in the terms and conditions of the tariffs. And payment methods can vary from direct debit, obviously, to credit cards and bank check. And I'm not going to cover the causes for late payment. I would like now to share with you a kind of what we could call a toolbox for an energy supplier to manage working capital first, but also bad debt exposure. So it first starts with the risk management policy and risk assessment at the very beginning of a relationship with a customer. Especially for business customer, the initial assessment, whether it is on an individual basis for biggest customers or via a scoring mechanism, is a very important step before deciding to have a contract with a company. This assessment can be done from internal information, or it can be also done via external information. A lot of credit agencies provide information about customers in all the countries in Europe. The credit management is also the monitoring. Permanent monitoring, as I said, the exposure is a permanent exposure which needs to be managed. The monitoring of the exposure is not only the monitoring of the settlement exposure, which is the electricity that has been already consumed but not paid yet. It's also, in most of our markets, the market exposure, which is the loss that a supplier incurs when the contract is interrupted earlier than the normal end, and the supplier has to resell the energy on the markets, sometimes at a loss. So two different exposure for the supplier, and in some countries given the volatility of prices, especially I'm speaking about the UK, the market exposure can become very high on more important than the settlement exposure. So once you have decided to enter into a contract with a customer, the terms and conditions and what is written in the terms and conditions is very important. You see the payment terms, number of days you have between the bill and the payment, generally 15 days, and the payment method. Sometimes it is written in the contract the way the customer is going to pay, and in some tariffs, the tariff is linked to the fact that the customer pays on direct debit, which is the most efficient payment method, at least for mass markets, whether it is small businesses or residential. Late payment interest, obviously, it is very important that it is included in the terms and conditions and at the very beginning. It is in most countries described by law as well. In Europe, we have a European directive about that, but it is important that the supplier specifies very clearly what are the conditions in terms of late payments and late payment fees. It's a very important tool on all the markets. And as someone said previously, the rate needs to be sufficiently significant in order not to be a cheap way of for someone to finance himself. Downgraded clauses, so also a very important tool for major customers, major business customers. So it provides a way of requesting a security deposit or guarantee in the middle of a contract. I said that the contracts are for fixed term periods. So when you enter into a 1 year, 2 year, 3 years period, it's not, you don't know already everything about the customer and his financial situation. And then you have these clauses in order to provide for a mechanism to ask a guarantee in the middle of the contract if the exposure increases or the risk increases. Mitigation tools are security deposits mainly, and very often it is as simple as that: security deposit, cash deposit, advance payments. We see that a lot in situation of risk in France and in the UK. Less often letter of credits, bank guarantee, or parent company guarantees for small companies, part of bigger groups. Margining is mainly for very big customers in order to cover the market exposure. So we require cash margins when the exposure increases, and it is written in advance in the contract, but it is also very often used in the trading markets, obviously. Credit insurance, not really always a tool to protect ourselves against bad debt. As I said, the contracts are for fixed term periods, and generally on the market, credit insurance are subject to a reduction of the guarantee at any time. So it's very difficult to find credit insurance for a fixed term period, firm credit insurance covering the full period of the contract. So it means that if the situation is getting bad for the customer, generally speaking, the credit insurer will react to that. But as a supplier, we have the obligation to supply until the very end of the contract. So it's not always completely appropriate. Factoring is a tool that is developing a lot these days, where the banks buy the receivables from suppliers. It's not really a tool for reducing the bad debt exposure. It's more a tool for working capital. Billing process, very important to have a very organized, industrialized billing process and collection process. I'm saying that it's obvious, but in electricity markets, we see sometimes debts that can be caused by the fact that the process hasn't been sufficiently quick in cases of change of tenancies or change of ownership of businesses. So it needs to be very industrialized. And then obviously the ultimate tool, which are the interruption of supply, which is possible for businesses in most countries, or order of justice, which are used also, statutory demands, wind-up process in the UK, or equivalent in the other countries, when the customer is not anymore supplied by the supplier. For residential customers, so I'm not going to go through all the details, but just risk management, credit checks are time-consuming, so not always very useful for residential customers, very expensive. They are scoring based on payment history, so in order to adapt the process, but it's less obvious. The direct debit is the main tool in order to avoid the debt to increase. Late payment interest and fees as well. Prepayment meters, in terms of mitigation. So prepayment meters are not used in all countries. They exist in the UK particularly. They don't exist in France. We can see that it is particularly efficient to make sure that people are not falling into debt without any capacity at the end to react. So it allows them to pay as they consume. So it's a very interesting tool. Payment agreements when appropriate, and obviously a reminder. I would like to highlight the importance of something which exists in the UK, in France, and also I understand that it is being discussed in Italy, which is the ability for the supplier to object to a change of supplier. It's very important in order to avoid that what has been seen in some markets in the past, customers switching suppliers in order to avoid paying their electricity. So with this objection to change of supplier, the suppliers can go through the full process, including interruption of supply as necessary if it is the only solution, without being interrupted by a change of supplier before the end of the process. It can also avoid people leaving the supplier before the end of a formal contract. Yeah. To conclude, quickly, so payment discipline is important for all suppliers. So I wanted to highlight that they have a number of tools for that, but it's subject to regulatory framework and market context. Ability to interrupt supply for non-payment is very important. Late payment interest being the norm, it's also key. Obligations for businesses to publish key information. I haven't heard a lot about that, but it's very important. Available data of payment behavior of customers, we spoke about that this morning. Responsibility of payments on customers, direct contract relationship. I am not aware of any or a lot of situations in the UK or in France or in Italy where the consumer is not responsible for the payment of the debt directly in a commercial relationship with the supplier. So I heard this morning that it was the case. In some situations you have a company between the consumer and the supplier. I think we don't have that a lot in our countries, and I can understand that it makes the collection of payments very difficult. Administrative penalties for late payments being in discussion on already voted actually in France. And that's it really. You wanted me, Alexander, to react on something in particular. Sorry, I don't remember what you said about.
I said that, first of all, I wanted to find out, very briefly, we only have about 10 minutes left, and we need to provide some time for Arnaud. Just one question. Can you disconnect, can the supplier disconnect of the consumer in France?
Yes, the supplier has the ability to disconnect, although there are obviously some constraints. People on social tariffs can't be disconnected. We can only limit the capacity. And also during the winter, there is a new law in France which has started this year, which prevents the supplier to interrupt the supply during the winter for all customers, for all consumers, residential customers. But apart from that, the interruption of supply remains an important tool to put an end to non-payments when it is absolutely necessary. And it is obviously a last call too.
Спасибо.
Thank you very much, Mr. Tanguy. My conclusion is that in France you cannot disconnect in winter and you cannot disconnect the socially unprotected groups of people. But Russia is much bigger than France, and probably there are more people like that in Russia. And the winter is longer and harsher. So in Russia, the arrears and the payables. Arno Williams, you have about 5 to 7 minutes, and I would ask you to comment on what has been said. Certainly we will pass your presentation on to the participants of the forum. It will be on our website, but I would just like you to react to those challenges that we mentioned.
For inviting me here again. I'm always very happy to be here. One of the reasons is because we are all in the same market, we all share the same experiences. I learn a lot about the experiences of the Russian market, and I hope to share a little bit of my experience on the European market. But there we go directly into one situation that not everyone is aware of. The European market is not one legal system, unfortunately. So we are faced with 28 different national laws and 28 different systems. Like Erwan of EDF already said, he made distinctions between various countries of what is possible and what is not possible. If we look at, if you look at the EU level, energy is not an EU competence as such. So all the legislation that comes from the EU level has basically to be implemented in national legislations. And that means that you have national law implementing an overall European law, but every national law has its own history and its own way of doing things. So also its own procedures. So if you want to disconnect a customer, it's different. The procedures are different in every European member state. That's important to know. The EU has, of course, certain powers to ensure that the laws are rightly implemented and that there is enforcement. And energy, I have to say, is basically the worst area in the EU. Many laws are not completely implemented or correctly implemented, and there are many procedures against member states for this. So the EU, the European Commission, starts procedures against member states for wrong implementations. Now, but to go to national law, I don't go too much into the business law, I think, because I think Erwan of EDF has pretty clearly explained how that worked. So it's basically a contractual issue. As long as you arrange things in a contract, you can almost do whatever you want, as long as it's not against the public order. Very simple. But I like the idea, and that's one of the things I also wanted to stress, is that you can now stop your clients to switch suppliers. That is something that comes up, and that is something that Russia could also consider, I would say. So then if we go into the public law part, as I call it, which is the real end consumer part, there the problem is, on the one hand, perhaps smaller than in Russia, but on the other hand, it's still 10% of the households on average in the EU which are facing problems with electricity payments. And 10%, that means if you have 500 million people in the EU, that means 50 million people, which is still a lot. And what is the difficulty in this sector is basically consumer protection laws in Europe, and it's the right to affordable energy. Now, how does the EU approach this? Basically two ways: economic measures and non-economic measures. Economic measures are specific basically price incentives, so protection for social groups. 22 European member states have protection for social groups, for certain categories of people having difficulties to pay. And another way they try to solve it is state support. Give allowances, give benefits, and also very proactively help finding cheaper suppliers. Help consumers finding more energy efficient solutions. So 50% of the customers, the end consumers in the EU, has been approached and has been in discussions with their government about energy efficiency. Also as one of the ways to, let's say, make the electricity or the energy cost more bearable. Now, non-economic measures, basically there is, what is very important is that there are very good systems in Europe for, let's call it personal bankruptcy. So someone takes over basically your financial administration and helps you paying for all the bills. That's something that, I don't know whether it exists here, but it could be something that could also be worth to consider. It's basically someone else takes over your finances and makes sure and also makes the payment for you from your own account. So that avoids sometimes having to cut off people. Further, there is always a notice period. And what I also liked was there is in Ireland at this moment an initiative, a voluntary initiative from energy companies to improve payment from consumers. And that has resulted in 31% less disconnections than the year before. So 2013 saw 31% less disconnections than the year before. And basically by prepayment systems, what we already use often in the business market, by early engagement of the electricity company with the clients, building risk profiles, debt restructuring policies. So that could be an interesting thing to consider. Further, there is also a lot of emphasis on complaint mechanisms, basically establishing a dialogue between consumers and energy supplier. And that is, you can call it an ombudsman procedure, you can call it some kind of a dispute settlement procedure, but it means that you maintain an engagement with the consumer that doesn't pay. So you, in a way, keep on the pressure on the consumer there. And at the end of the day, there is, of course, the national courts and the European courts, and there is enforcement through bailiffs, no question about that. Recently, there was even a very interesting European court case that basically allowed to German customers not to pay for their energy because they were not rightly informed of a price increase that their supplier had enacted. So the court found the consumers here in the right because there was no right information on the reasons for the price increase. So it goes pretty far, the consumer protection once in a while, but it helps the transparency, and the transparency helps, I think, the consciousness or the awareness of the need to pay. So I think, in view of the time, perhaps I should initially leave it like that, and I'm happy to answer any question. Is that okay?
Okay, Arno, we should close the session right now.
In conclusion, I would like to say the following. First of all, I would like to extend my deepest gratitude to everyone who participated in this session, to all my colleagues. I would like to thank our representatives of our executive authorities, to businesses, to the colleagues who came from abroad, to Tanguy and Arno. Thank you very much. Unfortunately, I know it for sure that Leonid Akimov wanted to tell you much more about the grid problems, but we are constrained by time, and I will summarize it like that. We spoke very obvious things today, quite reasonable, and in my opinion, those things were obvious 2 years or 5 years ago. Probably the situation in our industry has aggravated. There were a lot of other difficult problems which we had to resolve. But what's a good thing is that both businesses and the executive authorities are going hand by hand, and that gives rise to hope that the legal framework will be corrected and amended, which will work for the benefit of the Russian Federation, because the well-working energy and communal services market is very important for the fuel and energy sector in general. Thank you very much, everyone. I will be glad to see you next year, and I hope that we will have an even better organized legal forum. And I thank the organizers of the forum for the opportunity to have this panel here today. Thank you. Goodbye.